Okay, so in this situation, we wouldn't use the balancing test?
Well, I think that the balancing test is really always needs to be present, is that the invasion of privacy and of course, the security, or in this case, the crime of child pornography possession.
But in this case, we're looking at the particularity of the warrant issued, and the warrant said that we were looking for voyeurism files. It did not say we were looking for child pornography files. So in this case, the police went beyond the scope of the warrant, and the warrants are part of the balancing test.
Give me an example of where a right to privacy, where the government's interest in your balancing test overrides the right to privacy. Give me an example.
Well, I think
I'm a judge. What am I looking? What are you arguing? What are you telling me to look for?
I think that for instance, I think terrorism is a huge threat today. Of course, we see. I think we recently had the nuclear conference with Obama saying that there is a threat of nuclear.
Okay, there's
terrorism.
a threat.
So,
what's the balancing test?
of course, I think that you have to. There can be when the threat is imminent. I think that certainly adds to it. And when the threat is great to the security of people, then that would allow for a greater invasion of privacy.
And I think the Fourth Amendment issue today is that most, government action in regards to terrorism is more preventative than a punishment after the fact. And I think taking this into account when determining privacy should be looked at today with our new procedures.
Okay, let me switch you up here. Let's say that you are students at a university, that you're students at a public university, and the three of you conspire together to sell drugs. And the school administration goes into your email and finds this drug conspiracy. And now let me change the facts. Now you are at a private university. You are involved in the same conspiracy to traffic in drugs. And the school administration mines your emails between the three of you and turns it over. In both cases, the school turns it over to the authorities. Is the Fourth Amendment invoked in either case? And what, if so, what rights and does it protect?
Well, I think that we have the classic case of TLO v. New Jersey in the public university setting, that there is a great amount of pressure on the government to educate our students and to create a respectful and decent environment in the school. So I think that
we're talking about email. That's it. I mean, we're just talking about you emailing me and me emailing you, and the three of y'all getting together in a drug conspiracy.
Well, I think there's also
is the Fourth Amendment an issue in either case, and why?
Well, in the public university, it is a Fourth Amendment issue because electronic communication does hold some rights under the Fourth Amendment, such as in 18 U.S.C. 2511, which prohibits the government from intercepting such email communications and distributing them without a warrant or without official notification. However, with the private universities, third parties, they could be considered a third party and not necessarily subject to Fourth Amendment restrictions because the Fourth Amendment prohibits government intervention. However, we would argue that we should translate the values of the Fourth Amendment of privacy and the reasonable expectation of privacy to the private university.
If the private university is known for this, for getting information, turning it over to the police, do they become an agent of the government?
Well, if it does this repeatedly, it is an agent of the government. We can also see this pattern in certain hackers that get information from parties and give it to the government. Although this may be constitutional if it happens in some instances, if this is a repeated use, if the government relies on certain individuals to give them information regarding criminal activity, then they do become an agent of the government and are under the guise of the Fourth Amendment.
As a student at a public university, Lit time? Oh, I had a good one for you too. Good job.
Judge, please share some comments.
Well, I think the fact of the conversation that we just had is reflective of the complexity of the issues to begin with. Fourth Amendment law is not easy for starters, and when the focus of the question becomes how the Fourth Amendment is to be applied differently, if at all, in the face of an increasingly technological world, the matter becomes all the more complex. And if anything came shining through for me as a result of this conversation, it was that you folks have a tight grip on the handle of the subject that we're dealing with. You understand it thoroughly and are comfortable enough with it to adapt to some sophisticated questions and finely drawn distinctions that a less developed grasp of the subject matter would not permit you to do. I thought you did a fabulous job. Thank you.
Judge?
I would tend to agree with that. The notion behind the Constitution is fairly simple. What does it say? What does it mean? How does it apply? And at the end of the day, that's the basis for what we're doing here. And you all have done a good job of working through all three of those levels of constitutional understanding, and that's what we expect. And it was good to see. So I appreciate it.
You know, if I was to close my eyes and think, okay, what does a former Supreme Court Chief Justice sound like? He'd sound like this guy over here. Your participation across the board was just fantastic. You know, we as judges, I mean, when we get involved in this dialogue, this exchange, and these ideas are thrown at you, and you respond in a reasonable manner, and you respond with the knowledge that you have exhibited. It speaks well of you, speaks well of your teacher, and all those people that are sitting behind you. They should be very, very proud of you today. Good job. Great job.